I'm Jennifer Novak. I represent people and businesses who own properties where there's a possibility of soil, groundwater, or soil vapor contamination. Now, often these property owners didn't create the conditions. So it's common for us to hear someone say, I can't be responsible for this. I didn't cause it. And there's a phrase used in the law called the Innocent Landowner Defense. Now that sounds fair, right? It sounds like you should be able to argue that you're innocent, you didn't pollute, you just own the property. But this defense isn't quite what it sounds like. Under federal law, there are only two types of private innocent landowners. Now, one category is for people who inherit contaminated property, and the other is for people who purchased property, but they also have to have both not known about any contamination at the site and had no reason to know about it. And that's the catch. It's not enough to claim you didn't have actual knowledge, and you can't rely upon your own personal due diligence to argue that that's enough to qualify you as totally innocent. Not only might you have missed something or misunderstood something, but there's actually a more formal process you have to engage in before you can avoid the legal obligation to investigate and possibly clean up an environmental problem. And going back to people who inherit a contaminated property, that's also not as easy or bulletproof as it sounds, because there are still issues of proof and questions to resolve before you're legally innocent under federal and California law. If you're looking to take advantage of this real estate market and have questions about how a threat of contamination affects property values or legal liabilities, call us. And if you found this video useful, please hit that like button.